we will start customers' rights and duties. Okay. We were discussing the banker-customer relationship. If I summarize what we have learned so far, we discuss who is a banker and who is the customer and what is the nature of the relationship between the banker and customer. And afterwards, we discuss the rights and duties of the banker. Those topics we have covered now. So we are going to next topic today, that is customers' rights and duties. Customers' rights and duties under the banker-customer relationship. Students, that you have to remember this. When it comes to customers' rights and duties, it's very important. If you analyze past 5 years, when it comes to banker-customer relationship question, they have asked questions from this area mostly. I would say 60% from banker-customer, under the banker-customer relationship, it's a customer's rights and duties. It's not difficult. It's easy. Very small area that you have to remember under the customer's rights and duties. Okay. We first refresh our memory. Who is a customer of a bank? Now you remember, customer, when it comes to banker-customer relationship, we consider under the law, the customer is any person who maintains any type of account. Unless a person has opened an account, the banker and the customer does not have a banker-customer relationship. You can have any other type of relationship. You can have a service agreement with a service provider. But the contract between the bank and that service provider is not a banker-customer relationship. It could be something else. Contractual relationship with regard to a service provider. There can be a situation where you provide a service to a non-customer. So that means that person has not opened an account with you. So that's a service agreement. Likewise, we can have agreements with others or parties, but they cannot be considered as customers unless that person has opened an account with the bank. Then you remember we discussed at what point that we consider the account is open, that we said account considered open at the point we allocate a number, because the number of the account is unique. You can't have the same number for two different accounts or two different customers. Or once the account is closed, you can't reallocate that number to a fresh account. So because of that, the number of the account is unique. That is a unique feature. So court consider the point that you open the account, not the time that the customer signed the mandate, or not the time that you approved the mandate or permission to open the account, or not the time that he deposit the money, but the time that you allocate the number, right? No transaction is necessary. That we discuss cases also. Then we said once if a person has dealt with the bank without an account, if he open an account later, that he become a customer of the bank from the point that he first dealt with the bank, not from the time that he opened the account. So for example, if I deal with the bank today without an account, I'm not a customer. But if I open an account in future, say 2022, then I become a customer, but not from year 2020, but from today. So there is a case that we discuss with regard to that also. So bottom line is this: the customer means a person who has opened any type of account. Any type of account. Could be a savings account, could be a current account, it could be a uh, loan account or credit card account, whatever. So if that person has opened an account, he is a customer, you and he, you have a banker customer relationship. It's a contractual relationship. So that is the summary part of it. Then we'll go to the customer's rights and duties. What are the rights? We'll take first. What are the rights of the customer? Right. Customer's right. First one, the first right that we are going to discuss is number one, a right to open an account. Right to open an account. Opening an account. When I say this, sometimes or most of the time you may misunderstand that any person has a right to open an account. So that means, in other words, you have a duty to allow any person to open an account. That is not the meaning of this right. You have to remember this. Please thoroughly mind this. It is not that the bank has a duty to permit any person to open an account, or any person can open an account without the consent of the bank. Not that. This is something different, right? Right to open an account means if you allow any person to open an account, you means the bank, right? You have a discretion. You have a discretion. When a person comes to your bank, when he says that I want to open an account, you have a choice. The bank has a choice. Bank can say, okay, so we will allow you. That's one choice. Though otherwise, bank can say that we have enough customers, so we don't want you to open an account, whatever the reason, right? You don't want to provide even reason, and you can say that we can't accept you as a customer. So that means you are not allowing, the bank is not allowing to open the account. So then there's no banker-customer relationship. This is not related to that. This is if you, the bank, allow somebody to open an account. That means that you have used your discretion and you have decided to allow or permit that person to open the account. Once he opened the account, then you have a contract, then this right apply. What is the right? Right is this. When you allow to open an account, bank has to act according to the given mandate to the bank by the customer. Again, I'm repeating, listen very carefully. If you allow a person to open an account in the bank, so then he become a customer. So then he get a right. What is the right? And you get a duty. What is the duty? Customer can give instructions to the bank. That you have to remember. It is not the other way. Right? The bankers think that we can give instructions to the customer. No. Right? He is the master and you are the servant. Right? So customer can give instructions to the bank. Bank has to accept the customer's instructions to operate his account. The right that you have to remember, customer gives mandate to the bank, bank has to act according to the mandate. That is the right of the customer. Then the question is, what is mandate? What is mandate? Can someone answer me? Is someone from Sampath Bank here? Anyone from Sampath Bank? No one. HNB? Can someone answer and tell me what do you mean by mandate? I would like if someone can answer, because I want a conversation. This distance learning, it has positive point and also it has negative points. Because since you are not answering me, I don't know whether you understood or not. Right? So then it's difficult to me to explain unless you answer me. Please, someone can someone answer what is mandate? Or shall I name a person? No one is answering. Okay, right. Then I will answer. Right. Right. Mandate is not the document that he signed. Right. I know that answer. Most of the time bankers say that the mandate is the document that the customer signed at the time of opening the account. Right. That is generally, or in layman words, that is okay. But when it comes to law, that is not the answer. The mandate, remember, if you want, you can write down this. Mandate is the authority given by the customer to the bank to operate his account on behalf of him. Again, I'm repeating. Please note down. The mandate means the authority given by the customer to the bank to operate his account on behalf of him. That is the mandate. That is the interpretation of the mandate. So how do you take it? The mandate. So mandate you take in a card, a piece of paper. So that is the document that you refer as the mandate. But what is actually given in this document? It's an authority. Authority. Right? What is the authority? The authority to operate his account. Now think, say I open an account. I open an account in a bank. Whose account is that? That is my account. Right? My money is in that account. The account is under my name. I open the account. So it is my account. Now if I ask who operates the account, who operates the account, but then the question, the answer, the bankers say customer operate the account. But actually, I have never seen customers operating their account. Right? So for example, we say customers operate their account. We have seen the customers are operating via mobile banking or internet banking, using internet banking or mobile banking. But when physically, if you go to a branch to deposit money or withdraw money, unless you have a ATM card, so what is the procedure? Say I go to withdraw money. I want to withdraw money, then I go to a branch and I say that I want to operate my account and withdraw money. Would you allow me to enter into your system and operate my account? Do whatever the transaction that I want? It is not the case. So who operate the account? Bank operate the account or bank employee operate the account. I give instruction. I give instruction sheet or withdrawal slip. That is the instruction in writing. So I give to the teller. So teller operate my account. Teller operate my account. The question is, if it is my account, right? If it is my account, how can you operate my account? Where's the authority? Where is the authority to operate my account? Right? You now know, right? What authority is given when at the time I open my account, I give the authority to the bank, the institution, right? To the bank to operate my account. So the teller or anyone in the bank can log into the system and can do transaction, debit and credit, whatever that you can do. So basically you enter into my account, you enter into my account and you see my balance and you do transaction debit and credit the way you want, but as an instructor. The authority to enter into my account is given by way of a mandate. That is why it is called authority given by the customer to the bank to operate his account. Most important part of that word is on behalf of the customer. So that is most important the part, right? That is the customer's right, first right. So customer has a right to give instructions to the bank. The bank has to act according to the given mandate or given instruction. So that is the first right. Here I have given a case to understand the theory more easily, right? The case is this: Hugh Bain versus Federal Bank of Australia. This is an Australian case. What happened in this case? This person had an account with this bank. It's a current account. It was a current account, and that current account was overdrawn. Right, overdrawn. There's a OD balance. So then what happened? He deposited money. He deposited some money. Now bankers know, right? When money is deposited to a OD account, what will happen? Right? So you obviously reduce the OD balance by utilizing that money. Set off that money and recover the OD. So that's what normally happens, right? In the system, when the money deposited to the account, automatically by system itself, OD balance will reduce by taking that money. Now, what happened in this case, right? This is very important. This is important to all bankers. This is the law. So you have to remember this helps your day-to-day activities as a banker also. So he deposited money. The special thing here is he deposited money with special instructions. I have bold that, highlighted that part, special instructions. Sorry, specific instructions. Specific instruction. Visheshita Upadesh Samaga. So customers can give specific instruction to the bank. So what happened here? That he gave specific instruction to the teller, right? He said the money was deposited to meet a check which could be presented to his account. So what has happened? His account was overdrawn. He has issued the check to a third party, and he came and deposited money to the account and said and informed the teller that I have issued the check. The check will come for realization. If check comes that you have to pay, this money is for that purpose. So that is the instruction given. I'm sure 90% or even 99% of bankers who are participating in this today's lesson also may never heard about this specific instructions. So what do? You normally take the money and reduce the OD balance. What happened here? Same thing, right? So then the manager, without informing the customer, set off the OD against the deposit. So manager, he wants to recover the OD balance, right? Disregard the specific instructions and recover the OD. So then what happened? Obviously, since there is no money, check got returned. When the check comes to the account, refer to drawer narration and return the check. So then what happened? This customer filed action against the bank. Then what happened in the case? It was held that the bank has no right to set off, and bank has to abide by the customer's instructions. So that specific instruction. So that is the decision. So that is the law. Even today it's applied, right? It has not changed. Remember, customer can give specific instructions to the bank. The bank has to obey by the instructions given by the customer, not your procedures or not your practices important, but the customer's instruction is the important here. Right. Any questions from this first right of the customer? If you have any questions, or if you need further clarification, you can ask now. Anyone? Okay, no questions then. So then I'll go to the next one. That is the second right of the customer, to stop the account, to stop an account. Right? To stop an account. In Sinhala we say ginuma nevat weemata. So customer has a right to stop the account. Now this is not close. Closing account is different. This is stopping an account, right? If I am a customer of a bank, instructions to the bank to stop my account. Stop my account for a short period of time or temporary period of time. So then remember, stopping an account is a temporary thing, not a permanent thing. Right? That is the difference between stopping of account and closing of account. Closing of account is a permanent thing. If you close the account, that is the end. Right? But stopping of account is a temporary thing. So you, or the customer rather, give instructions to the bank to stop his transaction of the account for a short or temporary period of time. So customer can cease the debit and credit to the account until further notice. So he can give instructions to the bank that until further notice, transactions in my account. Transactions mean debits and credits. Right? So then what is the situation? What is the obligation on the bank? The bank has to act on the instructions of the customer and stop debit and credits. So no debits and no credits can be done. Right? So if he has given a standing order, so that will supersede by this instruction. So then you can't pay the standing order. If he has issued checks, and if those checks presented during this period, what will happen? Checks will get returned. Right? So because the bank can't do any transaction, no debit and no credits. Right? The banks should not honor checks or pay any standing orders. That you have to remember. So then what is the situation, or what about the dues of the customer? Say for example, the customer's account is overdrawn, there is OD balance that you are entitled to charge interest. Customer gives instructions to the bank to stop the account. Now what is the situation? Now if you receive stop instruction, to stop the account, so bank has to act accordingly. So then you have to stop debit and credit. So that means that afterwards that you can't pay standing orders and no checks can be paid. What about the interest that already occurred on the OD balance? Right? That is given here, right? The bank can debit the account only to recover the losses, charges occurred before it received the stop notice. So basically, if you receive stop account instructions today, any charges or losses, whatever, incurred or occurred before we receive the instructions, that expenses or charges or interest we can charge or during this period, even the account is stopped. Right? So then the OD or OD interest that you can recover, even the account is stopped. Then what about the banker customer relationship? Account is stopped, no transaction can be done. Question is whether the banker customer relationship still valid or in exist? So answer is yes, the banker customer relationship prevails. Banker customer relationship is there. So therefore, all the other duties, responsibilities, duty of secrecy, and everything applies. Still, he is a customer. His customer relationship is there. Duties and responsibilities are there. So that is about stopping an account. Customer has a right to give instruction to the bank to stop his account. Second right of the customer. So any question, if you have any questions from stopping an account, that you can ask. No questions? Okay, then I'll go to the next one. Next one, the customer's right number 3 is closing an account. Closing an account. Right? What is the difference between the stopping an account and closing an account? Different, I already informed you, as I already informed you. Stopping an account is a temporary thing, maybe for a shorter period, week or 2 week or even months, but temporary. So once the instruction is taken back, the account comes to normal status. So that means you can do transactions. But closing an account is different. It's a permanent thing. It's a permanent thing. So customer can give instructions, or customer can close his account at any time. At any time. Right? So for example, a customer, maybe the best customer in your branch or your bank, maybe a multimillionaire, right, can just walk into the bank and say that I want to close my account now, immediately, right? So the question is whether he has a right like that. Can he just come and say that I want to close my account? Does he have to give prior notice? The answer is yes, he can just come and close his account at any time. He can close the account. That is the word that we have used here. Customer can close the account at any time. So that means at any time is just he can come and close the account. No prior notice is necessary. So customer is not obliged to give prior notice to the bank, right? Prior notice to the bank. Once you get the account closure notice from the customer, so you have to accept it and you have to close his account. Close his account and release his funds to him. Right? If it is a savings account or current account, if there's funds available in the account, if customer says that I want to close the account, and if we give that instruction in writing, that is very important, get the instruction in writing, then what you have to do, you have to close the accounts and then you have to return the money. How do you return the money? Normally we issue a bank draft for the value of the balance of the account. So then we return the money, right? So that's how we close the account on the request of the customer. Then another important thing that you have to remember, since the closure of account is a permanent thing, you can't reopen the account. Same account can't reopen. So same number can't be allocated. For example, say customer comes to your branch and say, I am dissatisfied with your service. I want to close my account now. So that is instruction. Then what you have to do is you have to say, so give your instruction in writing. So you get the instruction in writing, then you close the account. You close the account and return the money. How do you return the money? Right? You don't take cash from the box and give. So you issue a bank draft to the customer. Now, can the customer come in the evening and say, okay, I was little bit upset. That's why I said that I want to close the account. I changed my mind. Can you reopen my account? No, it's not possible. Same account cannot be reopened. So same number cannot be allocated to the customer again. Of course, customer can open another account, a fresh account, right? So previous banker customer comes to end at the point that he closes his account. Banker customer relationship closed, terminated in the morning, right? In the afternoon, the customer wants to open another account. That is possible. So then you allow him to open the account. Then you start a new banker customer relationship. A new banker customer relationship, right? What is important here is, if the account is closed, that you can't reopen it. That is because closing of account is a permanent thing. So then the next question is, I said when the account is closed, at the point of the account closure, banker customer relationship comes to end. Right? Thereafter, no banker customer relationship. You know, duty of secrecy is a obligation, is a duty cast upon the bank under banker customer relationship. Under the banker customer relationship. Now the account is closed, so therefore no banker customer relationship. So it has come to end. No contract between the banker and the customer. So you can't basically call him customer also. Right? The question here is whether, or rather, what happened to the duty of secrecy? Is it still valid or still prevails? Or in other words, do you as a banker still can't divulge information of the customer, former customer? Anyone can answer, please? Account is closed. No banker customer relationship between you and the previous customer now, right? You have information, right? He did banking with you, so you have information. My question is that, can you divulge the information? Is it, if you divulge information, will it be a breach of duty of secrecy? Can someone answer, please? No one. No one to answer the question? Yes. Can someone answer? Is duty of secrecy still there or not?
Still there.
Still there. Very good. Right? So, yes. Duty of secrecy, remember, once the duty of secrecy starts, that means when a customer opens an account, the banker customer relationship starts, a duty of secrecy starts. When the account is closed, banker customer relationship comes to end, no banker customer relationship thereafter, but duty of secrecy is go ahead, prevail. So remember, so the easiest way to remember is, once the duty of secrecy starts, it never ever ends. Never ever ends. So therefore, you can't divulge any information of the customer, even the customer has opened or rather closed the account. Still valid. Still valid. Right? So therefore, so you can't divulge that information, right? This, even though we say that we can't divulge this information, I have heard, right? I have heard, so bankers are divulging information. How do you divulge information? Knowingly? No, right? So you are careless, right? Sometimes I have heard some bankers, when they get together, they discuss certain things. You know that so and so, there is that the famous cricketer is having an account in our bank. You know, he came today and deposited 100 million check. So that's information that you discuss with another friend in a canteen or in a restaurant, right? So if that person is not an employee of your bank, that is a clear diverge of information. So that person can go tell to somebody else, right? So they likewise, remember, right? Sometimes negligently that we disclose certain information that can be a breach of duty of secrecy. Important thing is that you remember, right? Breach of duty of secrecy is a criminal offense that you can be jailed for 3 years, and also that you can be fined for 1 million rupees or both, right? So therefore we have to be very careful. If you want to become if you become a banker, or if you want to become a banker, there's a huge responsibility on your shoulders. So remember that. Now I said the bank customer can close the account at any time. No prior notice is necessary, right? The next question is whether the customer has to give instruction in writing. I said that you have to get the instruction in writing. So I have bold here, I have highlighted here, important, get the instruction in writing. For your safety, very important. Customer can give instruction in verbal, customer can give verbal instruction to close the account, to stop the account, or even he can stop a check by giving a call. But remember always that you can you can accept it verbal instruction, but you have to get his written instructions also for your records. Otherwise, you will be in trouble. That happened in this case, Wilson versus Midland Bank. What happened in this case? This person, he had an account with the bank. He had an account with the bank. He had the current account. So then one day he gave verbal instructions to the bank and asked the bank to close the account. So bank accepted correctly, accepted the verbal instruction and closed the account. However, failed to get that instruction in writing. That is the wrong. So that was wrong. So then what happened, that the checks that he had issued came for realization, all got returned saying account closed. Then Mr. Wilson filed action against the bank and said, I never give instructions to my bank to close my account, because he knows that he never gave instruction in writing. So what happened in this matter, bank couldn't prove that they got instruction from the customer. So therefore, the bank had to pay a huge damage compensation to Mr. Wilson. So therefore, remember the bankers and non-bankers also, if you want to become a banker, right, it's your duty to get the instruction in writing, right? You have to act upon verbal instruction. You have to accept the verbal instruction of the customer. That is possible, and that you have to get. You have to accept the verbal instruction. At the same time, for your safety, for the safety of the bank, get that instruction in writing. In writing. So, if you have any questions from this one, the right number 3 to close the account, you can ask if you have any questions now. Okay, you don't have questions. Right, then I'll go to the next one. Fourth one is right to interest. Right to interest. Customer has a right to claim interest, right? what do you mean by that? Right now, you know, customers can open different type of accounts. We have savings account, we have current accounts, we have fixed deposits account, right? In RFC accounts, right? Likewise, we can have, a bank can have different types of accounts. For the deposits account, the customer receive interest, right? If it is a deposit account, other than the current account, right? Customer receive instruction. Customer has a right to receive instruction. Customer has a right to receive instruction if bank has promised to pay interest, right? Then the rate of interest fluctuate in line with the prevailing market rate unless both parties have agreed a special rate. That you have to remember, and you have to write down that part, right? The interest rate, if the interest rate is not agreed between the parties, then the interest rate will decide based on the market rate, prevailing market rate by the bank. But parties can negotiate and agree interest rate also. So, for example, we say now, say I want to deposit money in a fixed deposit. Then I go and discuss with the bank. The bank say that we will pay 6.5. This is an only example, right? 6.5% per annum. Then I negotiate with them, right? We say now I go to Sampath Bank. Sampath Bank say, okay, 6.5 monthly. Annual rate, annual per annum 6.5 for fixed deposits. Then I say, no, look here, now commercial bank is paying 6.8. I want more. So then you can negotiate. You can negotiate and agree. So if bank now ultimately agree to pay 6.9% per annum for my to my fixed deposit. So then I deposit that money and we create a contract. We create a contract. What is the contract? My part of the contract is that I have to keep this money for a year in the bank, Sampath Bank. What is the Sampath Bank's duty? Sampath Bank's duty is to return the money at the end of the year together with interest at the rate of 6.9%. 6.9%. Question is, we say the Sampath Bank agreed to pay 6.9% per year and for a 1 year fixed deposit. Then I agreed and I deposited. Then after 3 months time, we say something happened like something corona, right? So no business, interest rate came down. Now the rate, market rate is 4%. So all other banks pay only 4%. Question here is, now Sampath Bank has agreed to pay 6.9% per annum for me. Can they reduce, saying that the market conditions are not good, so therefore all other banks has reduced the price or the interest rate, so therefore we are also reduce interest rate for our fixed deposit? That is not possible unless I agree. Unless the customer agree, bank cannot reduce the interest rate if it is a special type of account. That means if it is a fixed deposit. During the period, the bank has to pay agreed interest rate, right? Bank can change the interest rate, you know, and at the end of the tenor or period, fixed deposit period, right? If it is renew, at the point of renewal, right, the bank can change the interest. Or bank can say that we will renew at prevailing rate. That means when it is at the point of renewing the fixed deposit, the bank can decide what is the look at the market rate and decide the interest rate. Otherwise, During the period, the bank cannot change the interest rate. So right to interest is that. For deposits accounts, deposits account, the customer receive interest. Rate of interest fluctuate in line with the prevailing market rate. In special type of accounts, the bank has no right to change the agreed interest. Special type of account means fixed deposit example, right? Then I have given here a case, very important case, Foley versus Hill. Foley versus Hill. This has been decided, it's an English case, decided in England in 1848. So you see that 1848 they had a good banking system in England, right? So from them only we got the banking system in Sri Lanka. Our banking system came very say after about another maybe 50-70 years, right? In Sri Lanka it was established. So anyway, the case is Foley versus Hill. Now this case is important because of this, right? Now customers, they come and deposit money, right? What is our business as per the Banking Act, the interpretation of banking business? You remember there are two parts in the interpretation. The bank can get deposits from the public as acceptance of money deposits. So money deposits, right? So then how do we generate income? How do you create money? That you can lend money or you can advance. You can do any other business which is accepted by law or by accepted by practice of banking. So that is the interpretation. So therefore, remember that we are lending money. We lend money to the customer. Whose money that we are lending? The money deposited by the public. Customers deposit money. We take that money and we lend that money to other customers for higher rates. For higher rates, right? The question arising here was the question whether a depositor has a right to know how the bank has utilized his money, what interest that bank has received from that money, or what was the income of the bank. Out of that the income, what portion the bank has given, the bank is giving to the customers. So if I am a depositor, right, do I have a right to know what has happened to my money, right? Where the bank has invested this money, or whether the bank has lent this money. If it is has given as a loan, to whom that the loan has been given from my money. Whether as a customer has a right to know that. So that was the question arising in this case, right? Then what was the decision? Decision is given here. The money paid to the banks ceased to be money of the customer. So court said the Mr. Foley, he filed an action against the bank and said that I have deposited money in the bank. So I have a right to know what happened to my money, whether the bank has invested money or has lent a loan. If it is so, then whom has taken the money? So that, and what interest the bank has charged from the borrower. So those questions, they said they have a right to know as a customer, as a depositor. So the answer was, or the finding of the court, a judgment said like this: money paid to the bank by the customer cease to be money of the customer. So in other words, once you deposit the money, the customer, you have no right to that money. Only right that you have is you can get the money when you want with interest. So it becomes a bank money then. It becomes the bank's money. So the bank can use the money in the way the bank wants. So that is the important thing, right? So once a depositor deposit money, it is no more the money of the depositor. So bank can utilize that money or use the money the way they want, the bank wants. And if they want to, they can invest. If they want to, they can lend. Whatever the rate that they can decide. The bank has only the bank is only answerable to the customer to repay the amount deposited when customer demands. So that is the only obligation the bank has. What is the obligation? The bank has to return the money with the interest when customer demand. You remember, we take deposit from the public, payable on demand. That is what he mentioned here, right? If you have any questions, any question from right to interest, now you can ask, right? Do you have any questions? Okay, then I'll go to the next one. Right. Customers right, fifth right, right to draw checks, right to draw checks, right? As you know, issuing checks is related to current accounts, right? What do you mean by the customer, this right to draw checks? Customer has a right to draw checks. Current account holders have an implied right to issue checks. Implied right. Implied means not a written thing or written right. Right? In your agreements or in your mandate or your general business GBC conditions, right? Not mentioned. So you have not mentioned that the customer current account holder has a right to issue checks. That is not written. However, even though it is not written, it is a right of a current account holder. It is an implied right. It is not written, but implied right. The bank has an implied duty to honor the customer's checks up to the limit of the credit balance. So that when he has a right to issue checks, the bank has an obligation to accept his check and pay checks up to the credit limit. Up to the credit limit. That is very important. Second, it's a duty on the bank. Then the next one, customer can deposit checks to his current account. So further, he can deposit checks that he received from others also to his account. So bank has to then collect the checks. Collect the check. So customer, a current account holder, has a right to issue checks. Bank has a duty to accept the check and pay the check up to the credit limit. And also the customer has a right to deposit checks to his current account. Deposit in the sense the checks that he received from others can be deposited to his account. Then this case is important with regard to the check deposit and check payments. Joachimson versus Swiss Bank Corporation. Joachimson versus Swiss Bank Corporation case that you have to remember. This case is very important. The question is, when we say customer has a right to issue checks and also he has a right to deposit checks, whether the customer of one branch of a bank can deposit checks into some other branch of the same bank. If I explain this with an example, we say there is a customer in Borella branch, right? Borella branch of, we say, commercial bank. Commercial bank, Borella branch customer, he has a current account, right? We say now he has gone on a trip. Now he is in Jaffna, right? He has forgotten his credit card, or rather ATM card, or he want to withdraw money from his current account. So what he did, he got a checkbook. He has a checkbook with him, so he wrote a check and he deposit the check in in Jaffna branch of commercial bank. The question is whether the bank has a duty to honor the check or collect the check, right? Not the same branch, a different branch, whether the customer has a right and bank has a duty to honor the check or collect the check, right? That was the argument or issue in this case, Joachimson versus Swiss Bank Corporation. So what was and you can see it was decided in 1922. At that time, remember, we didn't have this uni-banking system, or rather the banks were not interconnected, or branches were not interconnected with central computer system. So therefore, right, you can imagine, right, no computers, all types of ledgers and books were there, right? One branch has no facility to access, rather see the balance outstanding of another branch customer. The only thing they can do is they can give a call to the other branch and ask whether the money is available in the account. So then the other branch has to get this book and turn and see whether the account has money. So that without a computer system. So what happened in this matter? This person, he got a check and he went to another branch of the same bank and he was to deposit the check and get money, right? So what was the judgment? The customer has to make a demand to pay money. First thing, this is very important to the bankers, that you have to remember when it comes to check clearance, or rather check payment. This is very important. First, in this case, the court has analyzed, discussed most important points of collecting of check and paying of check, right? So what court said, right? Collecting of check or paying of check, it has two parts, most important two parts. First one, to get the money, the customer from his account, the customer has to make a demand to pay, repay money. You remember when as per the Banking Act, where banking business says that we can take deposit from the customers, but only on one condition, that is that you have to return the money when it is demanded, right? So therefore, that you have to remember, the customer has to make a demand. Customer has to make a demand, right? Customer has to make a. How does he make the demand? How does he make the demand, right? How does he make the demand? He make the demand by issuing a check. Issuing a check. The question is, first part says the customer has to make a demand to repay the money. Say customer issue a check, but he has not signed the check. We say he has forgotten to sign. Question is whether the proper demand is made. The answer is there is no proper demand, because without the signature, the check has no value. Basically, it is not a check. It's just a paper, a piece of paper. Without signature, you won't accept, right? So therefore, first thing that when you pay a check, the first thing that you have to see is whether the proper demand is made or not. How do you see, how do you recognize or identify the proper demand is made? You have to check the check. You have to get the check, then you have to see whether the important material parts of the check is there. You check the date of the check, you check the signature of the check, you check the value of the check, value in writing and in figures, right? So you check all the features. If you are satisfied with the check, that means that proper demand is made, then you go to the next one. What is that? You have to see whether the funds are available to pay the check. So that is the second part, right? So remember, if you get a check, this is the way or this is the order that you have to act. First, you have to get the check. Then you have to see whether the all necessary parts are there in the check, and you have to satisfy that the check is in proper form. Or in other words, it's a proper check is presented. Then you go to the system and see whether the funds are available. So, say what happened without first checking the acceptability of the check. If you just go to the system and see whether the funds are available and funds not available, then you what do? You put a refer to drawer, seal and return. Now take this example. I come, right? I present a check format given by your bank. That is a leaf from my checkbook. I have written everything, date, amount, words in figures and everything. It's a but I have not signed the check. You take the check, right? So I have not signed the check and I gave the check to somebody else. We say A. Now A brings the check. A brings the check. And he also account holder of the bank and comes and he wants to, we say it is not a cross check. It's not a cross check, it's a cash check, right? And anyone then can take money, any holder can take money over the counter. So he presents the check and he wants to get money. So you get the check, right? And you right away, you see whether the funds are available in the account. Then you realize no funds available or insufficient funds available to pay the check. So immediately what do you do, right? You get the seal and you put refer to drawer seal on the check and return. Is that correct? Is that procedure is correct? The procedure is wrong. First thing that you have to find is that you have to see whether the check is properly presented or whether the proper check is proper. So now you know if the signature is not there, the check is not valid. It's not a valid check. There's no check actually. Now what has happened? Without a proper demand, you have divulged information to a third party. What is the information that you have provided? You have provided the information that there's no sufficient funds in the account to pay this amount. So that is a divulge of information, breach of duty of secrecy. If it is a valid check, then no problem, because it is an instruction from the customer to pay. And if there's no sufficient funds, you have a right to return the check. But when there is no check, that means someone has just presented a piece of paper, right? Piece of paper. And what you have done, you have put a seal on that and saying there's no money in this account to pay this amount. And that person now knows my account does not carry sufficient funds, no money to meet this amount. The information is given to a third party. So then I can sue the bank. I can easily say I never issue a check. This check is not a valid check. I have not signed it. Bank has not observed it. That's a negligent. And further, the bank has divulged the information to a third party. What is the information that they have divulged? That they have divulged that there's no sufficient funds in my account to meet this amount mentioned in this piece of paper. Say it's a check for 1,000 rupees. So that means the information that you have provided to A, the third party, the balance in this account is less than 1,000. So that is a breach of duty of secrecy. So therefore, remember that you have to follow the correct procedure when you are collecting and paying checks. First, that you have to satisfy whether the check is in proper form. Then you go to the system and see whether the money or the funds available to pay the check. That is the correct procedure. If the check is not in proper form, then you can't say that you can't put the refer to drawer. Right? You have to say the check is not proper, so therefore you are returning. Right? That is the remarks that you have to put. Then the second part of this judgment, if the check is proper, then there is another part. What is that part? The demand has to be made to the same branch during working hours. Now we go to our example. A Borella branch commercial bank customer has gone to Jaffna and has deposited the check to get money. Question is whether he has a right to do that. First question, whether he could get money by depositing a check from Jaffna branch. Answer is yes, he can. He can. Then the next question is whether he has a right to do that. Now this is confusing, right? Whether he can. Yes, he can, because you provide that service to him, right? Because you provide that service, right? Since the computer system is there, right? You can provide that service because Jaffna Bank branch can log into the system and see whether the funds are available, and also his signature is scanned and put into the system. You can see the signature, whether the signature is tally. Not necessary to come to Borella branch. From Jaffna branch itself, you can see, you can view the system. And if you are satisfied with the signature, you can make a guess, you can make a decision, and you can pay the check from Jaffna branch. You don't want to even contact the Borella branch. So you pay. Then the question is whether the customer has a right for that. He can do it and he has a right to do it is two different things. The answer for the second question, whether he has a right to do that, the answer is no. He does not have a right to deposit his checks to some other branch, because as per the Jorgensen case, the bank, he has to make a demand. Demand is the check, and he has to make the demand to the same branch where he maintains the account. That is, if, as per our example, the customer has to bring the check to the Borella branch. If he bring the check to the Borella branch, he has a right to get the money, and bank has a duty to accept it. Right? Then, not only that, he has to bring the check to the same branch where he maintains the account, and also he has to bring the check or deposit the check during banking hours. During banking hours, it has to be present. What do you mean by during banking hours? Or what do you mean by banking hours? What are your banking hours? If I ask from different banks, students from different banks, they have different banking hours. Some banks, they start at 9 and finish at 3. Some banks start at 8 and works till late, 8 p.m. Some banks works 24 hours, 365 days, including holidays. Some branches, right? Different bank has, even in the same bank, different branches, they have different time of working hours, different periods. So therefore, you may have seen, right, when you enter into a branch, bank branch, right, they have display this banking hours. You can see a note, a notice saying the banking hours are 9 to 2 or 8 to 4 or whatever. They have informed, they have noticed the customers. Why they have noticed the customers? Have you ever thought, the bankers, have you ever thought why we have put this notice here? Who wants to know at what time we are opening and what time we are closing? What is important? It is important because of this law, law principle. Joachimson versus Swiss Bank. Customer has to produce or present the check during banking hours. If it is presented during banking hours, the bank has an obligation, customer has a duty, so rather the bank has obligation, customer has a right for that to deposit the check if it is presented to the same bank during the banking hours, to the same branch and during the working hours. Now, what is actually happening? Right? What is practically happening? Right? If we receive a check from a customer who is not a customer of this branch, but a customer of the same bank, do we say that you have to deposit your check to the same branch to get the money? We don't say so. We say we don't say anything. We just accept the check. Right? Why is that? Because we have that facility, or we have that technology. What is the technology? Technology is that we are interconnected by a computer system. Remember, that is not an obligation of the bank. Obligation means that you have a duty to accept other branch checks. It is not the case. That is an extra service that we provide to our customer. Extra service. That is an extra service that we provide to customer. This is very important. For extra services, customer has no right. And it is not a duty to the bank. It is not a duty to the bank to provide extra services. So what are the extra services that we know today, right? The common extra service that we provide, almost all the banks provide the extra service, you know, ATM cards, ATM machines. It's an extra service. For the convenience of the customer, we provide that service, right? We provide that service as an extra service. So therefore, customer does not have a right to claim it, and bank has no duty to provide ATM machines for every customer. Now, for example, we say I am a customer of, we say HNB. If I have a right for ATM card machine, then I can say, I can demand the bank, I want an ATM machine near my house. So, because I have a right, but I can't ask that, or I can't demand that, because I don't have that right, because it is only a special service provided by my bank. So it's the discretion of the bank. If they want, they can have an ATM machine, or if they want, they can take the ATM machine. That is one special service that we provide. There are other services that we provide during the COVID time, that you remember, the curfew period. Banks visit customers, right? They have mobile banking units, ATM machines, mobile ATM machines. Those are extra services provided by the banks to customers. So therefore, it is on the discretion of the bank, as not as a duty, not as a duty. So providing ATM card machines, providing mobile banking, providing internet banking, providing ATM, mobile ATM machines, those are not duties of the bank, but as a special services to the customers, right? Under the banker customer, the bank is not obliged to give ATM cards or internet banking or mobile banking. So remember that all these are special services. Then the next part is the customer has to present the check during banking hours. So what is our practice, right? We normally when we say we close at 3 o'clock, we close at 3 o'clock sharp. Sometimes even 2:45 we close, right? So that is there. But if a well-known customer, the biggest customer of the branch, if he comes at 4:15 and if he wants to deposit a check and say that I have a cash check, I have forgotten my ATM card, or sometimes he can say that I got a check from another customer of your bank, right? It is a cash check. Can you pay the check after working hours? Now he comes. Say you close at 3 o'clock. He comes at 3:10. So 10 minutes late. So what do you do? So you may have seen that we sometimes we pay after working hours. So now what is the situation? Is that payment correct? The question is whether that payment is legal or is it illegal. Now the check is presented after working hours. Customer is obliged to present it during the working hours. Bank has accepted the check and also paid the check. Whether the payment is illegal. Question is that. The answer is payment is not illegal. Or in other words, payment is legal. Payment is legal. Payment is legal unless it is not disputed by the account holder. Payment is legal unless it is not disputed by the account holder. In other words, if account holder won't challenge, the payment is okay, right? If take this example, right? You know, customers, account holder can anytime give instructions to the bank to stop payment of a check, countermand the check, right? We say, I am an account holder. I have given a check to somebody else. We say someone, right? I have given a check to someone, but I don't want to pay the check. I don't want someone to take the money. So I give a check at 3:05 in the evening, knowing that bank is closed now. Bank is closed. So I give the check to someone, right? Hoping that he will present this check tomorrow morning. So now someone also a customer of the bank and is known to the manager and also to the staff also. So he brings the check, my check, at 3:10 p.m. So that is after working hours, and you, the bank, so no, since you know someone that you and also me, the account holder. So what you do, you take the check and you pay. You collect the check and pay. 3:10 p.m. So after working hours. Then the payment has gone now. tomorrow morning, early morning, when the branch open, you see that I am standing in front of you. Early morning, when you open the branch, I am the first customer. Comes to you and say that I have issued this check number 2255 for 100,000 rupees. I want to countermand the check. Don't pay. So next day morning, I comes and say, first customer. So that means I am under the impression that the check has not come yet for the payment. Now what has happened? The bank has now paid. That was paid yesterday after working hours. Now what is the situation? Now I am disputing the payment. Customer, the account holder dispute the payment. Then what is the situation? Payment is valid unless the account holder won't dispute. Now the situation is, now I am disputing, so the payment is not valid. Payment is not legal. If the payment is not legal, what is the obligation of the bank? Bank has to return my money. So when I say countermand my check, if you have already paid, that you have to return the value of the check, value that you paid to a third party, the summon, you have to return to me. So that is the risk that you have if you collect the check after working hours. Then how do you recover your money? So then you have to go behind someone and get the money, not from me. I can't be penalized to the wrong that you did, the bank did. So therefore, I am entitled for the money. So bank has to return my money and has to go behind someone and take the money if it is possible. Right? So that is the right to draw checks. So if you have any questions, you can ask now. If you have any questions, you can ask. Customers' right to draw checks. Do you have any questions? Do you have any questions? Okay. Since you don't have any questions, then I'll go to the next one. That is now rights of the customer. We now finished. Now we are going to discuss duties of the customer. Duties of the customer. What are the duties of the customer towards the bank under banker-customer relationship? Right? This is very important. Remember, you have to remember two cases. Very important two cases that you have to remember under this topic. Sorry. We'll see the first one. Duties of the customer. First duty of the customer, duty of reasonable care. Duty of reasonable care. What do you mean by this? The customer has an implied duty to exercise reasonable care when he gives written orders or instructions to the bank, so that A, not to mislead the bank, B, not to facilitate a forgery. Not to mislead the bank or not to facilitate for a forgery. Customer has a duty. Customer has a duty towards the bank. Customer has a duty to exercise reasonable care. Reasonable care. When he gives written orders to the bank. What is the common written order or instruction the customer gives to the bank? Right? That is checks. Right? Each and every time when current account holder issue checks, he gives a written instruction. What is the written instruction that he gives? He says that debit my account and pay this much of money to this person. That is a written instruction given to the bank when he issue a check. This duty is established under this case law. The case is London Joint Stock Bank versus Macmillan and Arthur. This case is well known as Macmillan case. That you have to remember as Macmillan case. Sometimes for the exams, they have asked this question in different manner. They ask, what is the Macmillan theory? Macmillan theory means this, reasonable care, right? They can ask what is duty of care of a customer towards the bank, or they can ask without saying any duty of care, they can ask a question like, what is Macmillan theory, right? Macmillan theory is about reasonable care. I will explain now what happened in this Macmillan case. Then you will understand what it is, right? This Macmillan is a current account holder of a bank. He issued a check. Right? You know, in a check, the value of the check that you have to write in words and also in figures. In words and figures. Customer has to write, when he is writing a check, he has to write the value of the check. You see, like this, right? In words and also in figures, right? In this matter, this person, he issued a check. He wrote the value of the check like this, right? It's a £2, right? The value of the check is £2. He wrote the value only in figures, not in words, right? And he signed this check. He signed, and it was we say it's a cash check, right? And this check is given to a third party. So this third party, he took the check and he altered the check. He put 1 here and put a 0 here. This is now altered. Initially, the original check was written for the value of £2. Now, the third party altered the check, and the value is now £120. This happened, say, 200 years ago, right? I don't know. We say 100 years ago, right? The value of £2 means that's a huge amount at that time. Now, after altering the check, now it is 120. So it's a big fraud. Now, big alteration, material alteration. So, after altering the check, third party deposited or presented the check to the bank. Bank didn't realize or recognize any alteration. So what happened? The bank paid £120 from Macmillan's account, customer's account. Then the customer realized that the bank has overpaid. Bank has paid £118 over extra. So he gave instructions to pay £2, but bank has paid 120. That means 118 pounds has paid against his instructions without any instructions. So that was his argument. So what he did, he filed action against the bank. Action against the bank. Right? Under what? Under breach of banker-customer relationship. What is that? Bank customer has a right to give instructions to the bank. The bank has to abide by the instructions of the customer. The first right of the customer that we discussed today. So he said, Macmillan said, I gave instructions to pay 2 pounds, but bank has paid 120. That is not my instruction. I gave instructions only to pay 2 pounds. So bank has breached. So he claimed 118 pounds back. So what happened in this matter? The bank, they argued, customer has a duty. Customer has a duty. When he gives written instructions to the bank, he has a duty of reasonable care. He has a duty of reasonable care. What is that? What do you mean by reasonable care? When he gives instructions to the bank, he should not give misleading instruction. That is one. The other one is, should not give a written instruction which facilitate for a forgery. Now what happened here? The Macmillan has given instructions. That instruction has facilitated, the way he wrote the check has facilitated for forgery, because he has not written the value in words, and also he kept a space between the pound mark and the $2. So pound 2, right? So therefore, easily the third party could alter the check, quote the thing, by putting 1 here and 1 here, a 0 here. So this is breach of duty of reasonable care by the customer. So therefore, it was decided in courts, since the customer has breached the duty of reasonable care, the bank is not obliged to return the money to the customer. So therefore, the Macmillan's case was failed, and court said the customer has a duty of reasonable care. So this is called Macmillan theory. Right? Everyone, are you clear about Macmillan theory? Do you understand what is Macmillan theory is? Or do you want a clarification, or do you have any questions? If you have any questions, or if you need further clarification, that you can ask now. I'm ready to even explain it again. Are you clear, everyone? Right. So then, since you don't have any questions, and since you have understood what is Macmillan theory is, then I will go to the next one. Next one is duty to disclose forgeries. Duty to disclose forgeries. What is that? Right? Second duty of a customer, implied duty. Right? Not written, implied duty. Right? This says customer has an implied duty to inform the bank if he discover any forgery about checks or account. Right? In other words, in simple word, if I say this, say if I have, take this example. Say I have a current account. Then I realize someone has forged my signature and has issued checks. Say I noticed this last week. Last week I noticed. Then what is my duty? If the forgery, the knowledge of the forgery came to me immediately at the first instance, that I have to inform the bank. I have to go to bank, or I have to inform the bank that some forgery has happened from my account. At the first instance that I came to know. We say now that is my duty. Duty to disclose forgeries. Say I notice it, but I didn't inform the bank. So I think, or I thought, okay, we'll wait and see whether this will happen again. Then after a week, then I realize again someone has issued a check. Now I go to the bank and I inform. So then I have breached it, my duty. What is the duty? Duty to disclose any forgery at the first instance that I receive the information about the forgery. So that is the duty of disclosure of forgeries. This theory or this principle of law or duty of customer has been discussed in Greenwood versus Martin's Bag case, also known as Greenwood case. That is easier to remember. The first case that we discussed, that you can remember as Macmillan case. So then you will remember the Macmillan theory, right? Macmillan case, the judgment, the theory is called as Macmillan theory. Here, the Greenwood matter, this is known as Greenwood case. And also this law principle is known as Greenwood principle. What is Greenwood principle? I will explain, I will tell you the details of the case, then you will realize. What happened in this matter, Mr. Greenwood, he had an account. In this bank. It's a current account. It was a current account. One day, Mr. Greenwood realized someone has taken money from his account. He got a bank statement, then he went through the bank statements, and when he went to the bank account, when he reconciled, he saw some checks has been paid from his account which were not issued by him. So he knows what are the checks that he issued, but these numbers that he has not issued, never issued, but paid from his account. So then he normally keeps his check at home. So therefore he knows that no one can take the check leaf from his checkbook unless someone from home, from someone in home has to take. So he then questioned his wife. He asked his wife whether you got check leaf from my checkbook and whether you forged my signature. So then wife said, yes, I got some check leaf and also I forged your signature and took money. I took money to help my sister who is sick. So therefore, she said, sorry that I got money. So now what happened? Actually, that is a forge. It's a forgery. Someone has forged the signature. So a wife has forged the signature of husband. And it is a forgery, but Mr. Greenwood didn't inform the bank. He didn't inform the bank. The first instance, what is the duty now? Duty says at the first instance, if the knowledge of a forgery comes to the customer at the first instance, at that moment itself, that he has to inform the bank. Now the forgery has happened and it has done by his wife, and the customer obviously can't inform, so he didn't inform the bank. So then what happened? So now time went. So after another couple of months, he got his statements, and he now checked the statements. And this time also he realized that some of the checks have been paid from his account which were not issued by him. So now he knows who is doing this. So he straight away went to his wife and he questioned. Then again she admit that she again forged his signature and took money. This time Mr. Greenwood was so upset, so he said that I am going to inform the bank. So the amount is now high. So he thought now he can take the money if he inform the bank. So he said, so I'm going to inform. So he went to inform the bank. So meanwhile, Mrs. Greenwood committed suicide. Right? Now she dead. After the death of Mrs. Greenwood, Mr. Greenwood filed action against the bank and said, these checks were not issued by me. Those signatures are not my signatures. Actually, those signatures been forged by my wife. So forged signatures. Forged signatures. In future, that when we discuss checks under Bills of Exchange Ordinance, Section 24 says, if the signature is forged, the check is not valid. So therefore, Mr. Greenwood said, since the signature, my signature is forged, check is not valid. So therefore, the payment made by the bank is incorrect, wrong. So he claimed the money. He claimed the money. What was the argument, counter argument of the bank? The bank said, yes, we have paid forged signature check. That is correct. We have no right to pay. That is also correct. However, customer has an implied duty. The implied duty of the customer is to inform the bank at the first instance when he knows a forgery or knowledge of forgery comes to him. He has a duty, the customer account holder has a duty to inform the bank immediately. But in this instance, Mr. Greenwood has not informed the bank at the first instance that he got to know about the forgery. So therefore, he has facilitated for further forgeries. So therefore, the court decided Mr. Greenwood cannot claim money or value of the checks from the bank. So his case was failed. That's it. That is known as Greenwood theory or Greenwood case. So those are the two things that you have to remember: Macmillan theory and Greenwood theory. So if you have any questions that you can ask now from Greenwood theory and Macmillan theory. Do you have any questions? Okay, then we'll go to the next one. Duty of a customer, whether the customer has a duty to reconcile his account. Customer's duty to check and reconcile his account. Right? Third one. What is that? Now, you may have seen, right? And you have experienced that banks send customers statements, monthly statements, account statements to the customer. Bank sends customers bank's account statements. And sometimes I have seen some banks in the statement of account at the bottom or at the top of the statement, or even sometimes in the back side of the statement, there are a statement, rather a note is written to say the customer has to reconcile his account, right? And if there is any irregularity or a wrong entry, the customer has to inform the bank. Customer doesn't inform the bank within 14 days. The bank consider the account statement are correct. So bank customer is bound by the statement. Something like that, something that effect, the notice given to the customer. Question is whether there is any obligation on the customer to check his account and reconcile his account. So in other words, if there is any wrong, that he has to make it correct, inform the bank and make it correct, right? The answer is there is no obligation or no duty on the customer to reckon or check his account and reconcile his account. It is the duty of the bank to operate his account correctly without any defects. So because you are operating the account on behalf of the customer, so you operate the account, you have to operate it correctly. So customer has no duty to obligation to check his account statements or reconcile his account. This case, this was decided or this was discussed, this theory or duty of a customer to check his account was discussed in Thai Hing Limited versus Liu Chong Hing Bank case, right? That reference also I given here. What happened in this case? This is a company, Thai Hing Limited is a company. They maintained a current account in this bank. This I think it's a Singaporean case. So they maintain account in this bank. Over a period of time, employee of the bank, of the company, account holder has forged the signature of the authorized signatory of the company and has taken money from the account of the company. So all this time, the bank has sent account statement to the company. Account statement, monthly account statement was sent to the company, and with the notice to say that the customer has to reconcile his account. If there is any irregularities, that he has to complain to the bank, or otherwise the bank will consider the accounts are okay or in order. So that narration was there, notice was there. However, the company, after a few years, that they realize some checks that were not issued by the company has been paid from this account. So there was a huge money lost to the company. So then what happened? They filed action against the bank, and they claim that money paid without a proper signature or forged signature, right? Money paid with forged signature checks. So they claim the money. The bank's point was, bank said that we have sent statements to the customer, and further we have put a condition like this. What is the condition? The customer has to check his account statements and has to inform the bank if there is any discrepancies or any irregularities, that he has to inform. That condition we have put, but the customer never informed us. They have not realized, they have not informed us, so therefore they have breached the duty that we put on them. So what was the decision? Court said the bank cannot impose further duties on the customer. You can't, the bank, by your own decision, you can't put duties on the customer. You can't say that you have to do that, do this likewise, right? So therefore, the argument of the bank was rejected, and the court allowed grant a judgment in favor of the company and said the bank has to return the money, the forged signature checks values, to the customer again. So that was the decision of Thai Hing Cotton Mills. So Thai Hing Limited case. This case is known as Thai Hing Limited case. That same principle applied in Sri Lankan cases also in several cases. I have given here given only 2 cases, but there are a lot of cases decided on this principle in Sri Lanka by Sri Lankan court also. One case is Capital Rubber Estate versus National Bank of India, and another case Collatus versus Bank of Ceylon. In these 2 cases also the same principle applied by the bank, rather the court, and said bank is liable to return the money if it is a forgery check, right? It is not the duty of the customer or the account holder to reconcile his account and inform the bank. So those are the duties of a customer towards the bank. So that is the end of the customer's duties. So we have now discussed who is a banker, who is a customer, what is the banker customer relationship. Then we discuss the duty of the banker. Then we discuss rights of the banker, right of the banker, duties of the banker. Today we discuss right of the customer and duties of the customer. So that part is over. If you have any questions that you can ask now. Next week we are going to discuss classification of banker customer relationship and termination of banker customer relationship. With that we can wrap up our 3rd lesson, that is banker customer relationship. So thank you very much. If you have any questions from customers' rights and duties, you can ask. We have another few minutes. Yeah, we have 4 minutes. So if you have any questions, that you can ask now. Do you have any questions? If you have any questions, you can ask. Okay, so no questions. So that means that you are okay with the lesson. So thank you very much for participating for today's lesson. Next week at the same time, 1 o'clock Saturday, we will meet and we will discuss. Next day we are going to start with classification of banker customer relationship. The second topic is termination of banker customer relationship. So see you on next week. Thank you very much.